Shouldn't be doing that.
Energy efficient.
Absolutely.
That'll please Derek.
Thank you.
Right.
Okay now, Sarah?
Yeah, I'm just waiting for it to come on. Yeah, I'll let
It's a
you
little
know.
bit like, shouldn't be doing that.
Energy efficient.
Right. Yeah, we're on. We're on.
Thank you. Good evening, members, and welcome to officers. Welcome to the meeting of the Planning Committee tonight, which is being held remotely. We're recording the meeting, and the recording will be available on the Council's website following the meeting. The meeting is also being streamed live on the Council's YouTube channel, and the link is provided on the Council's website. Please note that any comments posted on the chat feed of the Council's YouTube channel during the recording of the meeting will not be monitored by the Council. All mobile devices should be switched off or set to silence, so the meeting is not interrupted by ringtones. Please switch your profile to mute unless you are speaking. For each item, officers will present the report, and then, as members will note, this is a slightly different format of the meeting tonight than for normal meetings of the Planning Committee. As there is no reports on Planning Committee reports for us to read through, we will be going straight into any questions on the officer reports in front of us. I will come to, as in previous meetings, I'll come to each member individually if they wish to raise any questions to us tonight. Agenda item number 1, apologies for absence.
Yeah, we have Councillor D. Morris substituting for Councillor Turner, and we have apologies from Parish Councillor McPherson Davis.
Thanks, Sarah. Item number 2, declarations of interest. Do any members have any declarations of interest?
Yes, we're very interested.
Thanks, Councillor Morris. Agenda item number 3, the minutes from the previous meeting. So I'll come round to each member individually. And Councillor Carol Morris.
Agreed.
Councillor Don Morris.
Abstain.
Councillor Fellows. Sorry, Councillor Fellows, you're on mute.
Agreed.
Councillor Brown.
Yes, I cannot turn my mute off.
Councillor Rimmer.
Stay.
Councillor Kettle.
Agreed.
And I also agree on the minutes, so those have been carried. Agenda item number 4, the design guidance, development and control guidelines, which is on pages 9 to 14 of your agenda. And I'll hand over to Mr. Gill.
Okay, thank you, Chairman. Can you hear me? Yeah. Can you hear? Okay. Yeah, relates to the revocation of section 1 of the Basildon District Council Development Control Guidelines. And it relates specifically to section 1, which is in respect of the residential development guidelines, the residential infilling and extensions to properties. Say the council currently has an array of design guidance, including this, and the government itself has introduced various new guidance in the form of the NPPF. The original guidelines were adopted by the council in 1997, and they are quite out of date in that respect in terms of the prescriptive nature. Yes, a national guidance in the form of the NPPF, the planning practice guidance, and various manuals for streets, as well as the recently introduced national guide, provide a more comprehensive guide towards design than the development guidelines that we've got at the moment. It should be noted that the council has, on the 28th of June 2018, endorsed the Essex Design Guide. This is quite a comprehensive guide and covers aspects such as architectural designs, internal details, layout details, and as well as technical guidance on highway standards and flooding issues. And it's felt that this provides a more comprehensive guide towards assessing new residential schemes than the development control guidelines that we currently apply. It also should be noted that various changes to permitted development in some respects run contrary to our guidelines in terms of back-to-back distances and garden depths, and so there could be some conflict in those areas as well. And so finally, let's say the council is looking at reviewing the or producing, sorry, a new design guide as part of the local plan, and it's felt that the continuation of development control guidelines could hinder that progress. It's therefore felt there's possibly two options in this case: is to revoke section 1 of the development control guidelines, which is recommended by officers, or retain it as it is at the present time. As they say, that ends my brief discussion on this matter. Thank you, Chairman.
Thank you, Mr. Gill. I'll come round to each member individually to ask if they have any comments or questions that they would like to ask. And then if a member would like to come back in at a later stage of this item, then just send me a message in the chat and I'll come back to each member from there. Councillor Fellows, do you have any questions to start off with?
No, we had, excuse me, we had a discussion on this at the briefing, so no questions this evening, Mr. Chairman.
Thank you. Councillor Brown? Sorry, Councillor Brown, you're on mute there.
Yeah, I'm having trouble turning my mute off. I think you can hear me now. Yeah, I keep pressing the button and nothing's happening, but that's why I couldn't vote earlier, so apologies for that. I feel that it just makes sense to do this. We've already adopted the other standards, so therefore to have two running in tandem just seems a little bit odd. That's my only comment, really. Thank you.
Thank you. Councillor Carol Morris?
Yes, I mean, as Mr. Gill pointed out, the existing ones are now 23 years old. I think we probably do need to update them.
Thank you. Councillor Don Morris?
I'd go along with that. They do need updating.
Thank you. Councillor Rimmer?
No. I really don't like this. I mean, sorry to the officer. I wanted for me to consider this properly and feel that I'm actually giving it the due diligence that it deserves. I would like to see some sort of matrix that's saying actually what's being lost in terms of what we have as technical requirements and what is already covered by the Essex Guide. Now, I've gone on to the Essex Guide and looked on the website, and it's very pretty. It's got all the icons and you can go under it, and it's very interactive. Yeah, and obviously a lot better than a 23-year-old document in terms of interactivity. But I am not so clear as if we're actually losing something here that protects our street scene, our residents in terms of proximity of new developments to the properties, and in terms of garden sizes, because I have been in many a planning committee meeting, I think, unless I'm completely misremembering, where these guidelines have actually been quoted, and we've been able to rely on these to actually have an understanding of whether too much overdevelopment was taking place in respect to a garden development, for instance. Now, I quite understand we need to refresh these standards, but I don't understand why we're going to get rid of them before we refresh them. That doesn't make sense. I can go along with the officer recommendation that there's duplication going on, but I would like to see it with my own eyes that duplication is going on, and that the Essex Guide actually does replicate in some way the standards that are set out and covers off the areas of concern that we often have when we're looking at some of the developments that take place. I also have a question about the appendix. So there's an appendix to the district and Basildon District development control guidance, and which relates to Greenbelt development, which doesn't look like it's covered in section 1. Is that something that would remain once you revoked section 1? Because it doesn't, I can't see any mention of that in the report.
Thank you. Before I hand over to Mr. Gill, just to summarise some of the changes that will be proposed through this. my understanding is that the Essex Design Guide, well, the Essex Design Guide has already been approved by this council and is something that we then look to for all applications that come before us. Therefore, it is the document that trumps all others when considering applications. And by having this form of duplication, by referring to the Basildon Design Guide, we're actually, if we rejected an application because it doesn't fit in with our Basildon Design Guide standards, we're actually putting ourselves at risk when a case may go to appeal. But I will ask Mr. Gill just to come back in there just to explain any changes that might occur. But we already have that Essex Design Guide that is the document that trumps all others.
Hello, yeah. In terms of the guide, there is a kind of they don't actually trump it, so they're both, you could say, in tandem at the moment. And if someone wanted to confuse the situation, they could use one guideline against the other, and it could conflict with that. In terms of the, I don't know if it's possible to share one of my screen. Is that possible? Hello? Yeah.
Yes, yeah.
Yeah.
If you click down the bottom, you can click the share screen. Yeah, if that's
if we click that one, just to show. Yeah, just going to show my the example from the Essex Design Guide. Can you see that? It covers like daylight issues.
No, it's not on there yet.
No, it's not on there.
No.
What is it? What's happened there then? Where is it on there? I don't know how it's working. I've just clicked on the button. Right. I've lost it. Where am I? It's not working on here. Go away. Which one do I have to use?
You should be able to share your screen and then click on the one that you have open.
If you want me to share my screen, I think I've got it.
Yeah, it's not showing up. Where is it? Oh, there it is. I found it. That's it. Found it. Yeah, found it. Is that now?
It's coming up.
Yeah.
Yeah.
Yeah. So this is just part of the Essex Design Guide, and this covers design section. So you covers daylight and sunlight. There are sections on garden size, and that's recommending 100 square meters for 3 to 4 bed properties, similar to what we've got at the moment. Recommends smaller sizes for 1 and 2 beds, as you expect. It then covers patio areas for corner plots. Then it goes on to some people quite rear to rear kind of distances, so overlooking issues. There's various distances required there in terms of direct overlooking. If you come down a bit further, there's, let's say, a minimum distance of 25 meters shown here. So it covers all those various issues I think Councillor Rimmer's concerned about, which I hope that covers that aspect. How do I close this now? Oh yeah. In terms of the Greenbelt policies he mentions, that was actually just a more like an appendices. They were covered in the actual planning policy section of the local plan, and I think they were just put in there as a reference rather than being part of the guidelines themselves. Hope that answers the questions.
Councillor Rimmer, do you wish to come back?
Yeah, so thank you on the appendix. That's a reassurance for sure. So thank you on that. For me, on my part, you've answered those specific questions that I asked in relation to garden size in terms of overlooking. But I would just say I do still question if we've had enough in this report to make it comprehensive, and just comprehensive enough to say that we're not losing any particular technical guidance comparing what we have now compared to what the Essex Guide has got. I was fully aware that we signed up to the L6 Guide in 2018 and that decision was made. I knew that it was something we're looking at in tandem. Obviously, on certain matters, I have seen this being quoted before by officers for reasons for either approving or refusing. So I just want to be sure before I make a decision on this, and I would prefer to defer it.
Thank you, Councillor Rimmer. Councillor Kettle.
Yeah, I have no technical questions at this time, Mr. Chairman.
Thank you, Councillor Kettle. Councillor Brown, did you wish to come back in there?
Only to say that the point of this evening is to say that we shouldn't have two sets of criteria running in tandem. We've already approved the Essex guide that is used throughout the whole of Essex. So it doesn't seem to have any logic or any credence for us to have a separate guide, particularly as there's not a lot of difference in them anyway. But even if there was, it needs to be clear to applicants and developers, and also to our officers, what guides to use. And I think also we need to remind ourselves that these are only guidelines. They are not stead and fast legislation. And with everything that's coming in our stead and fast legislation over the next month, we've got far bigger issues to worry about. But I do just think it's just a little bit almost perverse to have two sets of guidance, because then which are we going to point our developers to? And as council has already approved the Essex guide in line with all the other councils across Essex, it's just, to me, just have to have another set of guidance.
Thank you, Councillor Brown. Councillor Rimmer, I will bring you back in shortly. For me, I don't think we need to overcomplicate this here, but what does overcomplicate it is having two different design guides that cause confusion for applicants, for officers, for members. What we are trying to do tonight is to seek clarity for all concerned, and mitigate the council against any risk in the future. And I think that's what we're trying to put forward. Councillor Rimmer.
Well, we're probably going to have different documents that we're still going to be referring to. We're talking about design guide, yes, but there's a separate design guide for Billericay. And then there is different rules in other elements as well that we refer to all the time. I totally agree with the logic of Councillor Brown's argument. And I think I have no problem with that. My issue is with making an informed decision in terms of anything that we might actually be losing by doing this. My understanding from the report is that we're actually retaining the guide, but we're just stripping out one of the sections, which is the major section. So the rules on advertising will remain as part of this guide. And that's my understanding. I don't know, there's other elements that are retained as well. And whether the Essex guide covers advertising or not, I don't know. But for me, it would be useful to see each of the points, each of the elements that we're losing, each of the from the design guide from section 1, to see whether they are all covered off by the Essex guide. There's something which we did when we were looking at the powers of the committee, the powers of the chairman, the powers of the planning officer, the powers of the legal officer, in terms of where they should lie. There was a matrix, and then for each of the columns it was shown whether it was necessary or not, and we went through that. I just want to make sure we're not losing anything that's necessary just by accident. I suspect we're not, but I think it's my duty to actually make sure that we're not. And I'm not confident with the report I've got and my own ability to look at the guides and actually absolutely know that I would spot something. I do trust in the professional expertise of our officers to be able to do that and present that information in a way that I could make an informed judgment.
Thank you, Councillor Rimmer. Are there any other councillors that wish to come in on this item? Councillor Rimmer, you did wish to defer, and I haven't had a seconder for that, so we will go forward for the recommendation on page 9.
Could I ask for a seconder on that potentially to defer this item? If I don't get one, that's fine, but I'm just asking the question.
We will go forward with the recommendation on page 9. I haven't seen anyone come forward.
Oh, so somebody's put their hand up.
Is that yourself, Councillor Don Morris? So Councillor Don Morris, you're seconding Councillor Rimmer's request to defer.
Correct.
Is that correct? Yep. So we will vote on deferral. Like I said a few minutes ago, I don't think we need to overcomplicate this here. We've already approved the Essex Design Guide that we're seeking to refer to, yeah, I urge members to support the main recommendation that we have on page 9 this evening. So I am against the motion to defer. Councillor Brown?
I think she said in favour.
Yes. Mike, I don't know, I'm having trouble with my IT stuff. It's like a little bit delayed. Yes, against.
Councillor Fellows?
I'm against.
Councillor Rimmer?
In favour.
Councillor Kettle? Sorry, Councillor Kettle, you're on mute.
Oh, I think I've unmuted it now. Yeah, I'm against.
Yeah, thank you. Councillor Carol Morris?
In favour.
Councillor Don Morris?
In favour.
So with 4 votes to 3, the motion to defer has been lost. So we will now go forward with the recommendation on page 9 that committee revoke section 1 of the Basildon District Council Development Control Guidelines 1997 relating to residential development, and that the Essex Design Guide forms the main focus when assessing the design and layout implications of any future development proposals when determining planning applications within the borough. I will be voting in favour. Councillor Fellows?
In favour.
Councillor Brown?
In favour.
Councillor Rimmer?
Abstain.
Councillor Kettle?
Abstain.
Councillor Carol Morris?
In favour.
Councillor Don Morris?
In favour.
So with 5 votes in favour and 2 abstentions, that has carried. So we will now go on to agenda item number 4, design. We'll go to agenda item number 5, planning applications protocol on pages 15 to 23 of your agenda, and I'll hand over to Mr. Spears.
Yep, just a slight delay in demuting. Yeah, this one was a report that came before the committee back in February, 18th February, I think it was, this year. It was deferred as members felt that the report did not furnish them with sufficient information, where applications were refused contrary to officer recommendations, cost implications, and how members' views would be communicated to the planning inspectorate. What I've tried to do initially is sort of just as background, is just to provide a little bit more detail. I've made some references to probity in planning and a couple of reports by a consultant, and also a briefing paper for the House of Commons Library, just to set out a little bit of background in terms of how members, how officers produce their reports, and how members, can read those reports and how they can make their decisions. And then obviously that leads into a slightly more detailed sort of protocol itself. I won't obviously go through all the prior details. I'm sure you've read the parts that might interest you on that. In terms of the protocol itself, the sort of first phase, I suppose, in terms of members looking at an application for them is the technical briefing. Now, obviously, members have got to keep an open mind, and they shouldn't predetermine a decision, but the technical briefing is the opportunity for members, if they have a concern about an officer recommendation, if they have a concern about a particular issue or something, perhaps they feel that we haven't covered in our report in enough detail, to ask those sort of questions. And hopefully we'll be able to provide you with the answers, or if not, then, by the committee to either put your mind at rest or at least give you the information you feel you need to make a proper decision. When it comes to the committee itself, what we're suggesting from the protocol point of view there is that in respect of all applications where members putting forward a recommendation to make a decision against the officer recommendation, that they do need to fully explain the reasons for that against the relevant development plan policies or the NPPF or any particular material considerations. Now, where it's a grant of planning permission contrary to recommendation, this is where we're asking for here is that rather than resolving to grant, it really should be necessary. The committee should, if the committee had decided to do that, then they should resolve to defer the decision to allow the head of planning to go away, draw up a list of planning conditions, look at whether there's a need for a Section 106 agreement or any other matters that might need to be reviewed. If it's a major departure from policies, there may be an issue of whether it therefore needs to be referred to the Secretary of State before the final decision is issued, and allows all those matters to be resolved before members actually make their final decision on the proposal. It would be brought back to another committee to allow them to do so. Now, if an application is to be refused contrary to the recommendation of the head of planning, what we're really asking for there is that members are as precise as they possibly can be with the reasons for refusal, and obviously that these reasons for refusal must relate to specific and relevant planning grounds in relation to that particular case. Now, by doing this, firstly, it will give the officer or the head of planning the opportunity to come back and sort of point out where they feel there might be weaknesses in the argument, and give members a chance to sort of have another think on the matter. But it also makes sure is if we do stick to, because there are cases, where decisions are pretty balanced, and it's quite possible members will put different weights on different material planning considerations and come to a different decision. But so long as you are making that decision on the basis of good, clear development plan considerations, planning policy considerations, then it doesn't mean that the decision's unreasonable, and it does reduce the chances of us being taken for costs on an appeal. So I think there just needs to be that room for debate at the committee and room for officers to sort of point out and flag up where they feel there might be an issue. We would then, once we've been given the clear reasons for the refusal, the planning committee would take the decision. The head of the decision notice the head of planning would then draft the decision notice for the chairman of the planning committee to review. The wording used must clearly and accurately reflect the reasons for refusal voted at committee meetings. We can't sort of add very much to it because obviously clearly that's taking it outside what members have actually voted on. So I think that's why it's important to ensure that in these situations we do take the time in committee to make sure that the reason is clear, that all the members voting on it are happy that they know what they're voting on. Once the chairman has cleared that, we would also copy that to all other members of the committee as well for information. Then obviously the decision notice would be issued by the head of planning. If we then subsequently get an appeal against a decision which has been made contrary to the officer recommendation, we will provide copies of the agendas, we'll provide copies of the minutes, and we'll provide obviously copies of all third-party comments and copies of all the relevant development plan policies and guidance to the inspectorate as we're required to do. We will also notify by email all members of that particular committee with a copy of the agenda and minutes and any other information we feel will be of assistance to them, and be available to give advice to members that they can provide a letter or a report or anything they wish to support their reason, and assist them in forwarding that on to the inspectorate to allow them to allow it to be considered. What we would normally not do is provide an appeal statement in those circumstances. Now, there are some cases, householder applications, for example, where that isn't allowed anyway. The sort of the faster system that the inspectorate now use means it's just a questionnaire and copies of all the documents that related to the application and the decision notice. obviously you can add to, neighbours can add to it and members can add to it as well, but there isn't actually an official report. But even where it's a case where we might normally do a statement, we wouldn't normally do a statement if we felt that the planning matters that members had made their decision on were clearly set out in the report. If there are other matters that members felt relevant, planning matters, then we would do a short report to assist and make that very clear to the inspectorate what the grounds of refusal were. If the appeal is to be held at a hearing or an inquiry, where obviously that it would be helpful to have members of the committee there to defend their decision, then obviously we would contact them at a later date to explain what the procedures were and give them the opportunities to attend. So that's really what we're suggesting. I mean, it's roughly along the lines of what you originally saw, but I hope I've given you some background as to why we feel this is the best approach, and also perhaps just sort of filled it out a little bit, the various stages of how we deal with it. Thank you, Chairman.
Thank you, Mr. Spears, for your report there. And members will note from the executive summary that I've asked for this to be brought back for committee tonight, because I think that clarity at all stages of the process is important for all members, and I think that the protocol set out for us tonight adds to that clarity and puts us in a stronger position. I'll now go round to members and ask if any members have any comments. So I'll start with Councillor Fellows.
Yeah, thank you, Mr. Chairman. I keep losing the bit that I've marked, edited on my copy, but I think it's page 16, and it refers to if we vote contrary to the head of planning, and it references the development plan. Now, is it the way out of date local plan, or is it the yet to be adopted, the draft local plan that's with the inspector, or could that be interchangeable? Because we're often told that whatever plan people are referring to carries little weight. Just a bit of clarity around those two, please.
Thank you, Councillor Fellows. Mr. Spears or Ms. Lyons, are you in a position to respond there? Mr. Spears? Mr. Spears, you're on mute.
Okay, can you hear me now?
Yeah.
The development plan is actually a little bit wider than that. It does include both local plans to a degree. Where the policy has been saved in the old local plan, they obviously have still have a significant weight because they've been considered to be in accordance with the NPPF. But it also does include national planning policy guidance as well. So there might well be cases where we actually haven't got an up-to-date policy on a particular, and we actually are refusing it on the basis of the national planning policy guidelines rather than anything else. It also can include the emerging local plan, but obviously you've got to be wary of how much weight you give to those policies because they haven't yet been tested at examination. It can also include SPG, such as the Essex Design Guide. They're all part of it, and obviously they all have different levels of weight depending on how they've been assessed and at what level they've been reviewed. So obviously national guidance has significant weight, and obviously an adopted local plan has significant weight.
Thank you. Councillor Fellows, do you have any further questions?
That's fine, thanks, Chairman.
Thank you. Councillor Brown.
Yeah, I mean, to me, it just seems common sense that particularly where we decide to approve an application that previously our officers have recommended refusal, that then those officers have time to go away and consider things like Section 106 and conditions which they would have normally put forward if they were going to approve it, rather than having this slapdash approach of something will be thrown together later in conjunction with the chair. I think coming back to committee does make sense. I do feel there needs to be a time limit on that as to how quickly that can come before committee, because I think to expect applicants to wait longer, we can start getting into more difficulties with our timing. And so I think it's important that they do that. I can see why presently with the number of appeals that we've lost for various reasons because of committee decisions, it's really that we need to be extremely clear at time of committee and ensure that the reasons we're putting forward are only those that are clear policy, whether that is planning policy or the NPPF, etc. I mean, obviously we're still waiting for our local plan, and hopefully at some time it will eventually go before and come forward, so that, because that gives us then a set of guidelines that are easy to understand and have more weighting. But I do think it's important that as a committee we are very precise in when we go against officers' recommendation, and that we are clear that we are on using material considerations and not just those that may be politically motivated or out to keep a bunch of residents happy. Because sadly, we are bound by the legislation that our central government give us.
Thank you, Councillor Brown. I'll invite Ms Lyons to come back in there.
Yeah, I mean, Councillor Brown, that's a really good point about the reason when we put the decisions where you grant, which is quite rare, against our recommendation for refusal, is the fact that when Charles first started, Charles had to battle with a decision that was made against officer recommendation for refusal. It was an approval, and we had a mishmash of conditions and also a 106 that was never signed. And actually it was the applicant that in the end of the day actually owned up, and he then actually came forward with the obligations. He didn't have to, because we had an unsigned 106 agreement. So actually sometimes I mean, that's really important that we actually have a chance to go back and resolve 106 agreements, because obviously that is affordable housing and contributions, and also get the conditions right, because we don't want poor Charles to go through the months of anguish he had with that one previously. So it does make sense, and that you're quite right about returning to committee. The only thing is with 106 agreements, it can take a little while to get them drawn up in the heads of terms, but I think we should put, like we put on our normal decisions now, it should be 3 months, no more than 3 months, and if after that point they haven't signed the 106 agreement, then it needs to come back to committee for refusal, because obviously that would be they're not prepared to sign up to the 106 agreements for affordable housing normally. So I think we need to make sure we have that caveat put in that as well in terms of that recommendation. If you decide to approve subject to 106 agreements for cases where there's affordable housing, if they're not prepared to sign the agreement within 3 months, then it comes back for refusal on that point.
Thank you, Ms Lyons. I think again that adds clarity to the process for all concerned. Councillor Kettle.
No, I don't have any further questions at this time, Mr. Chairman, because I'm just reading it.
Thank you, Councillor Kettle. Councillor Rimmer.
Yeah, I have grave reservations about this policy. I must confess there's elements of it that just strike me as actually taking power that's been entrusted in us as members, elected members, away from us. And I understand the points that are being raised, but I see them being mitigated by the way the head of planning has actually handled and her officers have handled reports. We have seen them illustrating if there's been an issue with Section 106 or not. I mean, if it did come up that there was no Section 106 agreement in a meeting, I'm sure that would be highlighted, and then we could defer. We could all agree to defer on that basis. I heard the terms. I heard the phrase out of the principal planner, Mr. Spears, where he said that it will give members a chance to think again in terms of any delay. And I didn't like that, to be honest. I mean, this is we have to trust. We've got that power to make those decisions in a semi-judicious way. We shouldn't be predetermined, for sure. If anybody's doing it for political reasons or they're doing it for pressure from members of the public, that's absolutely wrong. We also all have to learn, officers and members, from the decisions that have been made. It's a welcome thing that the appeals are actually being brought back to us so we can find out and hear more about what's actually happened in those cases. But I think that also happens for officers as well. We've made a decision to refuse on the basis of bulk and in terms of the street scene, a development in Wickford the planning inspectorate agreed with us. Then the proposal was brought back again with only minor adjustments, and the officer still recommended for it to go forward. And for me personally, I didn't understand, and I'm not. I wonder if, I mean, I think we're guilty sometimes of not learning from the planning inspectorate's decisions. I think the officers are sometimes guilty. And I only say that because you're all human and we're all human. So I think we have a very useful function. And actually, we've got more of a mandate at the end of the day to carry that function out. And I feel that these proposals, as they are, strike me as undemocratic. And I'd urge members to strike them out as they are.
Councillor Rimmer, I don't see how they're undemocratic, because we're not taking away any rights of members to be able to vote on particular items. In fact, we're strengthening that by strengthening the role of committee within the process. So far from being undemocratic. Do you wish to come back there?
Yeah, I feel like there's an override written into the system. But actually, if there is a situation where, this is completely depersonalized, Christine. We're not always, we can't always be guaranteed to have somebody as good as you in the role. So it's about the functions, yeah. And in essence, there'll be an override potentially for the head of planning, whoever that happens to be in the future, 5, 10, 15 years time. That's written into this protocol, and it strikes me as undemocratic, because we were making a decision based on the information before us. Then we are told almost to think again. We've been told, Mr. Spears said that we'd have time to think it over again. I understand some of the logistic elements that have been raised, but I think there's other ways to mitigate for those. And changing the protocol in the way it's being changed actually seems to dilute our function.
I repeat the points that I made, that this is far from being undemocratic, but I will bring back in, I will bring in Ms. Lyons, who's indicated to speak.
Councillor, I mean, I get what you're saying completely, but the point is, and we have to remember, is the fact that you have made a decision. So a planning committee on the certain date, you make a decision to either approve or refuse something, which is within your grasp as members of the planning committee. You can make that decision. We can't change that. I think the point that I think probably misconstrued the point that Stuart was making is the fact that it's what you then get chance, if we bring the decision back to you again, or you see the decision again, it's whether you've got chance to reflect on all the points. But I think where we get to now, and where we've got to with those making those decisions, the fact that it's not, I think probably he used the wrong term. I'm not asking you to think again, because you've, in a public place, you've made that decision to refuse planning permission for something on those given grounds. All we'll bring back to you in terms of the refusal position is the fact that you will get to see it written in full, because on planning committee, normally it's given, we get the, you give us the ideas, we generally draft something on the night. If we think it's good enough, we'll let it go forward. If it's not, then we say we want to agree that in line with the chair of planning, and you will all get to see that to make sure you're happy that we've got it right. We give you advice at planning committee on what we think you can be effective on, and I hope any planning head of planning will give you that advice as well, because obviously what we don't want you to do is to put the council at risk of costs, and that's when you use the wrong reasons for refusal. And today you have listened carefully to what we have said, and you have made the right decisions. Now occasionally we have lost them where you refuse things, but you haven't made a wrong decision, because we haven't got costs, so you haven't put the council at any risk. But you've taken a different approach to the application. I get that. With approvals, we're not saying that you were wrong to approve things when we've recommended refusal. There is a case that where we must make sure that we attach all the right conditions. The conditions meet the tests, the Wednesbury tests of conditions, and also the 106 agreement is attached to it. We get the 106 attached to it. But actually we can't do that on the night, because we have to look at heads of terms with the applicant, and also the viability of the scheme with the applicant. So we can't say at planning committee, we're going to put 106 agreement on for the following heads of terms. We can't do that on the night. We're not allowed to, because we've got no idea the viability of that application and what the site can deliver. So it will need to come back in those terms. So we are not, as officers and future officers, are not trying to take any powers away from you at all. We're saying that this just gives the right to come back if we have to make the checks and balances. And it then goes into looking at that planning appeal approach to make sure that any planning appeals that come from refusals that go through the planning process, where you recommend against an approval by the officers, is the fact that that can be, you've got the right grounds to get through into the process. And we're setting out for you what we will and what we can do to assist that process and what we can't do. So I think in some respects it's a protocol that we're asking you. It's almost like, I think it's a protocol we're asking just so we've got an agreed position where what's going to be delivered for you. We're not trying to take any of your powers away. I can guarantee that, because you have made a decision in public, and that is to refuse or approve something. We can't ever change that. So we can't ask you to think again. We can't do that.
Councillor Rimmer.
Thank you for your answers. I was going to also raise the issue that in respect of appeals, where it does go to appeal, and this appeal statement, I would have thought that, and it's been raised before, I understand what you're saying in terms of protocol, but we get to write the protocol shortly if it's being put before us. And it's about officers providing an appeal statement for any decision that this committee actually makes. It seems to be that you're in the best place to do so, and you've been instructed by the committee what our decision is. So I would have thought that would be your function, to put it bluntly.
Thank you, Councillor Rimmer. Councillor Carol Morris.
Thank you, Mr. Chairman. On page 16, towards the top, there's a section of bullet points. Starting with discuss the areas of difference, then it says record the detailed reasons as part of the mover's motion, adjourn for a few minutes for these reasons to be discussed and then agreed by the committee. Now, I don't think that is right or should be right, because even if we discuss with the officers before the committee, the actual discussion together with our reasons for our actions should be discussed in the committee. So we shouldn't be adjourning for a few minutes for us to discuss them. People who are watching this committee and who watch the planning committees want to know what's going on. And I don't think that we should be discussing things whether it be with officers or amongst ourselves out of the committee. The committee is where you make the decisions. So, that doesn't seem to be, whilst I can understand, yes, we discuss it with officers beforehand, but if I discuss it with officers beforehand, I invariably also discuss it when we come to the committee meeting as well, so that people listening in know why and how we're doing this. It's what I like to feel is clarity for those watching what we're doing. The following paragraph talks about undue pressure being put on officers to come up with a form of wording. Well, often members don't have the correct technical wording for things. They call them by things which obviously the members of the public understand, but when it comes to being put into a technical document, we need it put into the correct technical language. So therefore we need the officers to be doing that for us, to be understanding what we're saying and using the correct terminology for the document that goes out to the applicant, and if necessary, when it comes to an appeal. And if you turn over to page 17, the committee's reasons should be clear and convincing. Again, it's a case of we need the officers to help us to express things in the correct terminology. So for those reasons, I'm unable to support this protocol as it's written. Thank you.
Thank you, Councillor Carol Morris. Councillor Don Morris.
Chairman, the points that have just been raised are ones that had occurred to me, and so that point's been raised.
Thank you. Is there any other member that wishes to address the committee? Councillor Brown.
Yeah, sorry, I just wanted to make the point on this adjournment. We adjourn the meeting in order to allow the public to speak, and then reconvene the meeting. That is not the same as turning the cameras off, and it's not the same as kicking everybody out of the room and going into part 2. So I think we need some clarity around the what we've determined the adjournment to be here. And from my reading, what we're saying is doing exactly the same thing as what we would do when we are allowing the public to speak, that we recognise that's not actually part of our official meeting, but is a function that can still occur in public. And so I'd like some, so I think that that's the way I've read it, and perhaps, Christine can clarify that, and that, maybe I'm wrong. I think what the second part, some of the things that Carol's saying about the role of the officers, I think there's some confusion here. I don't think our officers are saying they're suddenly going to abandon us and say, get on with it, but they can't put words into our mouth. They can't say to them, oh, do you mean, as they have done in the past, and crafted the whole thing for us, because that is where we're going to get into difficulties. Also, what members do need to be aware that when things go to appeal, the original report from the officers is part of that documentation that also appears there. So I know that some members have been concerned that the opposite view to what our view is going forward, but under the paperwork that has to go as part of that has to be that initial report and the recommendation made by the officers. So I think that we need to be clear here that it's not that our officers are saying they won't support us or help us, it's just that they are limited in what they can and can't do. Thank you.
Thank you, Councillor Brown. And I think we've had that reassurance from the comments that Ms. Lyons said earlier on, that we won't be left alone in any way. We will be supported. We have access to that support. But as Councillor Brown, you quite rightly said, they cannot put words into our mouth. The other point that you made as well, of once and Councillor Morris, I can see that you've indicated, so we'll bring you back in shortly following Councillor Rimmer. But once an agenda has been published with an officer's recommendation, that's in the public domain, that recommendation as it currently stands, and an applicant, if they wish to challenge a decision that we have, they already have the officer's report. No one's proposing that be changed. It's there in the public domain to be able to be used as part of that appeal process. What we're seeking to do is add clarity here around the role of members and the role of officers in that appeals process, so that we don't put ourselves in a position of danger in the future. Councillor Rimmer.
Yes, thank you, Chair. I think my concerns, at least, are born out of the need for transparency and making sure that it's quite clear in respect of our responsibility in the decision-making process in terms of this. I am concerned that these proposals are being brought when they are being brought in terms of timing, especially as residents have been generally complaining about the lack of consultation over the town master plan and various different building developments that are being planned for various parts of Basildon without
Councillor
consultation.
Rimmer, if I can just ask you just to get your point.
I am, please, Chair, if I may. Yes. This is all related. All related. So development's going to, some of these matters may come to this committee, and I want to make sure that we're not just tweaking protocol to try and get one result over another. And that may be the charge that's laid against us if we are not, if we pass this. And so it is a matter of transparency and doing right by the voters and doing right by our elected function.
Thank you, Councillor Rimmer. No one's trying to bring in protocol unnecessarily, we currently don't have a protocol, which makes it even more important for the reasons that we should have a protocol. And the timing of this, we first discussed this in February of this year, and it's right that we get this matter resolved. I'd also like to bring in Ms. Smith, who I believe is indicated.
Sorry, no, I didn't. If I looked like I had waved,
apologies,
waved my hand.
It did look that way.
I
Sorry,
don't have
Karen.
anything else to add other than what Christine and Stuart have said, unless anybody's got any direct questions for me on that.
Actually, Lindsay, I've got one actually. It's a point that Councillor Brown made, and actually it's a point that I was going to raise with you in a minute actually. It's the fact that when we use the word adjourn, I think we need to, that's a point that Councillor Brown is actually quite right, because are we seeking to like, we have a break, we stop the committee and we go into a private recess to talk about the reasons for refusal? Is that done in private? Or, which I think the point which I was a bit, and Councillor Brown, you actually, I was thinking that I get your point there. Or is it a point where we go into a we're still live on camera, but we go into some internal discussions? Which is it? Because that's, I think Councillor Brown, you made a good point there, because is it an off-camera discussion, or is it an on-camera discussion, but we're out of committee? And that's what I think is not very clear in the protocol. And my point that does need a little bit, just a little bit more explanation, because that is quite important. Because I've had committees where we've had to take the committee out to make decisions because we've had challenges over legal issues, and we've had to close committee, and we've had to stop the committee, and we've had to then take all members out, clear up a legal point, and then bring them back in again. Or is this a point where members are in a sort of a recess position where the cameras are still running, but they're making we're having a discussion around the reasons for refusal? And which one would it be? Because I think that's quite clear. We know what to do in planning committees in the future, because I think that is a point that I think that probably needs a bit of clarity. I'm asking for some help.
Yeah, no, and I think that might be something that we are going to have to consider in more depth, and because I think it will depend on the issues that are arising. Clearly, members need to, there needs to be we need to be open and transparent in this decision-making process, and it has to be the members' decision with the members' reasons, not reasons that have been suggested in a private session. So I think that's where we need, certainly, as has happened before, planning officers can assist with putting the reasons into the right wording and that type of thing. But the reasons have to be the committee's reasons, and I think it wouldn't be appropriate for those reasons to be discussed in a closed session. But there may be instances where there does need to be a short adjournment to clear up a point, or it might be that planning and legal need to have a discussion around whether something is actually going to be an enforceable point, and we may need to have those discussions to come back and advise the committee on that reason. That would be a different type of discussion, I think, where we would potentially need a short adjournment.
So that's fine then. So basically, we're not taking the committee out of circulation. That's fine. I think we just perhaps might need to make a slight amendment to that. Just that if you're going to agree to the recommendation, the decision of the committee is that we resolve that it's taken. You make that point very clear, the fact that the committee at all times will remain as a committee, and the decisions are made in a transparent way. So there's no behind closed. I mean, we can look at the wording for that. I think that's quite important, actually.
Thank you, Ms. Lyons and Ms. Smith. Councillor Morris and then Councillor Brown.
Yeah, I just wish to say that the discussion that's been had and the comments that made by Councillor Brown and Ms. Lyons rather emphasise the point I was making, that the way this policy has been written needs to be looked at again because there are inconsistencies, there are things that people can misinterpret. Therefore, as I said, you know, I don't disagree that we need a policy, but as this one is written, I don't think I can support it.
Councillor Brown.
Yeah, I just want to reiterate something that's been said. I mean, Councillor Rimmer is saying that this in some way takes away our democratic powers and all of those kind of things. What I would say is previously, when we chose to approve a plan application that officers had recommended refusal for, that then went away. We never again saw what the conditions were. We never again saw whether or not there was or wasn't a section 106. The fact by putting it into protocol that when we say we want to approve this against recommendation, that then it has to come back to committee where we get to see the conditions in place, actually gives us more powers, not less. It gives the public more transparency, because those then conditions are being seen in the way they would have been where an application is approved or is recommended to be approved. So, Councillor, in fact, this gives more to us, not less.
Thank you, Councillor Brown. How did I know Councillor Rimmer was going to indicate to speak next?
Thank you. No, look, there may be good elements of this, and I accept some of it as actually, you know, I'm not going to be dogmatic about this. I mean, I did accept some of Christine's arguments that she put forward. I thanked her for answers. There's elements of it I still don't like in terms of the protocol. So yes, asking for section 106, if we've approved it, that sounds sensible. Making sure that we are approving the refusal reasons, that all seems sensible. The elements I still really can't, which I don't like, is this appeal element. So when it goes to appeal, the officers are not actually going to back up the decision of this committee and actually produce an appeal statement using their professional expertise. I have a problem with that. I also feel that there is an element of a check that has been semi-indicated, indicated but retracted. So indicated by Mr. Steers but retracted by the head of planning about this think again. And to me, it did feel like a think again when I read it. So when Mr. Spears said it was a think again, it resonated with me, unfortunately. And I think that's how the members of the public are going to see it as well. And I am worried that where the public have been bounced into a consultation process over the town master plan, there may be an attempt, or seen to be an attempt, and perception can be key in democracy, to actually bounce us into making decisions over the town master plan and not giving it the due diligence that it deserves.
Councillor Rimmer, I'll remind you that we're considering here a protocol here tonight on the council's processes, not any planning application, and I wish to remind you of that. We will now proceed to the recommendation. I stand by the comments that I've said throughout this meeting tonight. This is about strengthening the role of the committee. It's about putting in place clarity where there currently isn't, which is also putting this council in a vulnerable position. And I think it is right that we approve this protocol this evening. What I am proposing with in line with the comments made by Councillor Morris and Councillor Brown, is an amendment on page 20 on the first paragraph, to remove the section that says members should consider whether it would be helpful to adjourn the meeting for a few minutes for those reasons to be discussed and then agreed by committee. I think that sets out, by removing those words, I think it sets out quite clearly that the meeting will be a public meeting at all times. So I'm now going to proceed with the recommendation on page 15 that the protocol for managing planning applications determined by the planning committee, contrary to the recommendations of the head of planning, be approved. I will be voting in favour. Councillor Fellows.
I'm voting in favour, Chairman.
Councillor Brown.
In favour.
Councillor Kettle.
Favour.
Sorry, Councillor Kettle, could you repeat that?
Yeah, in favour.
Thank you. Councillor Rimmer.
I'm against.
Councillor Carol Morris.
Against.
Councillor Don Morris.
Against.
So with 4 votes to 3, that has carried. That brings us to the close of our meeting tonight. Thank you all members for your attendance. Councillor Rimmer?
I'd just like to raise that I would like you, as a chairman, to consider how you're running this meeting in terms of how questions are asked and how voting is done. I'm sorry. I'm sorry, Councillor Brown indicating like that is unacceptable. I'm just saying in terms of democratic services and how we run digital meetings and the protocol, I do feel that there's an element of priming that's going on. And I think that this needs to be considered.
Sorry, Councillor Rimmer, I do not understand your points there. They are not valid, and that is a close for
Of course it's valid.
This is now a close for the meeting tonight.
And
Thank
I
you
will
all for your
raise it
attendance.
with democratic services if you're
wish you all-
not prepared to consider it of your own volition.
I wish you all a safe journey home, or for those of you that are already at home, enjoy the rest of your evening.